KCRW sponsors include Amazon Prime Video, presenting All In, The Fight for Democracy, featuring Stacey Abrams, now Emmy-nominated for Outstanding Writing for a Nonfiction Program. All In, The Fight for Democracy is available at consideramazon.com.
You are not the president or the vice president's lawyer.
He won a case, a big case.
Your loyalty is not to me.
Well, he was a lawyer for me for one of many.
It's to the law.
Well, I don't know. I haven't spoken to Rudy. I spoke to him yesterday briefly.
The Constitution.
He's a very good attorney, and he has been my attorney.
People of this nation to guarantee justice.
Which makes me perhaps the most innocent man anywhere in the history of the United States.
This is Josh Barrow, columnist for Insider and host of KCRW's Left, Right, and Center. You're listening to All the President's Lawyers, the podcast about the legal problems of presidents and their associates. Because all presidents have legal problems, though some have more legal problems than others. My co-host is Ken White. Ken is a criminal defense attorney and former federal prosecutor. He writes the Popat Report newsletter on Substack. Hello, Ken. Welcome back.
Hello, Josh. Thank you.
So let's talk about former acting Attorney General Jeffrey Rosen. Rosen became acting Attorney General upon the resignation of Attorney General Bill Barr last December. Tension between Trump and Barr had risen, including over Barr having told the Associated Press that the Justice Department had not found sufficiently widespread election fraud to affect the outcome of the 2020 presidential election. Rosen became acting AG in mid-December to serve for about 1 month, and of course, Trump at that time still very much would have liked the election outcome to be overturned, and so Trump continued to pressure the Department of Justice to get involved in various ways, perhaps by putting out a letter or making statements to Georgia lawmakers saying that the outcome in that state was fraudulent or at least suspicious, and that they should intervene. And Rosen did not end up doing this, but one of his deputies, Jeffrey Clark, who was then the acting head of the DOJ Civil Division, did want to. So Clark worked a back channel with the president, proposed a plan to intervene, drafted a letter for DOJ to send to Georgia lawmakers that would have urged them to intervene in the election result. And when Rosen vetoed the ideas of doing any of these things, Clark then made a proposal directly to the president to fire Rosen and install him as acting attorney general. The two of them even ended up in what was described in the New York Times as an apprentice-type meeting at the White House in early January, with Rosen arguing that he should keep his job and Jeffrey Clark arguing that Rosen should be fired in his favor. These matters have been covered in the press for months. Everything I've described here is as it was reported in the New York Times. But now Jeffrey Rosen has testified about what happened to the Justice Department Inspector General and also to the Senate Judiciary Committee. So, Ken, what happened here is obviously a very important governance matter. This effort by the former president to misuse the Department of Justice for his own personal purposes, to make specious legal claims and factual claims about the election that he had lost. Could these investigations produce anything beyond a report about who tried to do what, or is this a legal matter? Could Jeffrey Clark or anybody else face legal consequences for what they tried to do here?
I don't see the legal consequences here, Josh. It's historic. There should be political consequences. And in a more just world, this would follow Clark around for the rest of his life. But despite all the people assuring us very confidently that this was a RICO, I don't really see the crime here or the violation that could lead to some sort of proceeding. So nothing happened ultimately. And what they were contemplating doing was really making statements. And it's not clear how that would be a crime.
So the nature of the statements, there could have been public statements. There were also court filings that the former president wanted made from the Justice Department. Is any of this a misuse of government resources? Basically, the Department of Justice is supposed to be there to do the government's legal business. If you try to commandeer it for your own political purpose, is any of that a misappropriation or a fraud or anything like that?
Unlikely. It's not a fraud because, typically a fraud is trying to get money from somebody by false statement. And that's not what this is. What we're talking about is the president urging the Department of Justice to take an official stance that we believe to be taken in bad faith and false and for the president's personal electoral benefit, which is certainly extremely inappropriate and could well be a basis for impeaching the president. But I don't see how it's a separate crime of any sort. And indeed, I think it would be very difficult to get into the sort of analysis where in court as opposed to in an impeachment proceeding, you're second guessing what a legitimate position by the Justice Department is or isn't. So as absolutely outrageous as it is, and I don't want to downplay that, it's not clear to me how it could be a crime or how it could be something other than something that Congress wants to establish for the historical record who did what.
So this is basically a separation of powers issue, right? It would be weird for the courts to look at what positions DOJ had taken in court or had considered taking in court and not just rule against them and basically say it was a misuse of executive branch resources to take this position when you came to court. That's supposed to be a matter for the executive branch, not a matter for the judiciary?
Yes, that's right. I think it would be very difficult for the court to, in effect, police the line that way. I mean, a court can find that Department of Justice's position is wrong and can even levy kinds of sanctions, not the sort of monetary sanctions you'd normally levy against individuals, but basically impose consequences in the course of a case. But it would be, I'm not aware of any precedent for basically prosecuting somebody for taking the position on behalf of the government in a case like this. And I think it would be very difficult on a separation of powers basis.
What about the bar? Could Jeffrey Clark face any sort of bar proceedings because of what he did here or tried to do?
Yes. Now that is a possibility. And we've seen recently some willingness by state authorities to get involved in that type of thing. For instance, in Rudy Giuliani's case, where the state high court that handles attorney discipline getting into the false statements Giuliani made in the course of some of his ridiculous litigation on behalf of Trump. So I think historically, state bars have been reluctant to get into this sort of politically charged controversy and to use their discipline mechanisms as a way to police it. But that reluctance may be eroding because of the outrageous and historical nature of some of the conduct surrounding the 2020 elections.
Obviously this is not the most important thing that Jeffrey Clark did wrong, but in addition to trying to misuse the resources of the Department of Justice, he was also insubordinate. He was not the Attorney General or the acting Attorney General, and he was going around the back of the acting Attorney General to deal directly with the president to try to reset the strategy of the Department of Justice. Now, that makes him a terrible employee, and you might want to fire him if he did something like that to you, but is that misconduct beyond just being a bad way to be an employee?
It's misconduct with respect to his position in the Justice Department. And you're right, that's the sort of thing that might get you fired. But it's not any sort of criminal act. It's not something that's likely to have consequences outside the context of the Justice Department where he no longer works. I mean, Clark is the one who had the, I think, accurate read on what Trump was like and what Trump might be willing to do. And, probably very nearly got Trump to do it. So he might have had stars in his eyes as being the next acting Attorney General. And it seems that he got very close to being that.
Going all the way back to January when this started being covered, one theme in the coverage of Jeffrey Clark was that this behavior was sort of surprising to people who knew him, both people who were who liked him and people who are critics of his. Thought this seemed a little bit out of character, that he was sort of nerdy and rumpled, not really the sort of political operator that you would expect to do this. And it sort of has me wondering what exactly Jeffrey Clark thought he was up to. Because, Mark Joseph Stern, the legal writer for Slate, wrote earlier this month that Jeffrey Clark has a sweet new gig because he's the chief of litigation and director of strategy at the New Civil Liberties Alliance, which is a conservative/libertarian public interest law firm. They do things like sue over COVID vaccine mandates and the eviction moratorium. But that doesn't really sound like a sweet new gig to me. Jeffrey Clark used to be a partner at Kirkland & Ellis. Usually one of the things that if you're someone who came through big law and then you go into one of these big jobs in the Department of Justice is that maybe you expect to go back into big law when you're done, make way more money than you were already making and you were already a partner. Jeffrey Clark is not a partner at Kirkland & Ellis or any other similar firm, doesn't seem likely to get a job like that in the future. So whatever he thought he was up to, it certainly doesn't seem like positioning yourself to have a great cushy job after you leave the Department of Justice if he had somehow managed to become acting Attorney General for literally less than 3 weeks.
Well, I mean, it depends on what you consider to be a sweet new gig. Certainly, if you're in it for really big bucks, that doesn't seem to be where he's landed. But if you're in it for prestige within certain political circles, for access to certain political circles, and for prominence within the Trump world, that may be what he's interested in. He might want to be the sort of person who can pick up the phone and call, I don't know, Mike Lindell or Roger Stone or someone like that. That may be what he considers to be a sweet gig.
You can get on the phone with Mike Lindell.
Yeah, right. Maybe that's what thrills him. And maybe he's a true believer in some of this stuff. And, now in this crazy divided partisan world where there are, all these groups of super partisan, super true believer people, he may have found his niche of the group that he wants to be admired by.
So in addition to this drama that was going down in Washington, D.C. with regard to the Justice Department, there was a U.S. attorney in Atlanta, BJ Pak, who resigned on January 4th quite abruptly. And he's now told congressional investigators he did that because he was told that the president was going to fire him for refusing to allege widespread voter fraud in Georgia. And so he doesn't put that directly in the president's mouth, although we do have this audio recording of the president complaining about this never-Trumper U.S. attorney in Atlanta just a couple of days before Pak ended up resigning. But so that seems like, yet another data point about how the president was raging about this, trying and ultimately failing to get the DOJ to involve itself in Georgia.
Right. I mean, I think he saw the writing on the wall. Trump was flailing around at this point, very mad at different people for not, promoting his narrative vigorously. I don't think there's indication that Pak was a never Trumper or really that much of a partisan at all. I think he was just a fairly mainstream, straightforward guy who wound up in that position, but who wasn't willing to go full Jeffrey Clark on the situation. And he didn't want to be fired, which is a perfectly reasonable stance to take. But yeah, Trump's call that we have the recording of certainly suggests that he was very agitated at him. And he may have just decided he didn't want any part of that.
BJ Pak, I would note, is a partner at Alston & Bird.
Right. So it's not like he's out on the street or anything. More likely, I think he made the calculation that for his reputation and dignity and future prospects, going out this way was the best thing for him. And he's almost certainly right.
Let's take a break, and when we come back, we will talk about Mike Lindell and Sidney Powell and the Dominion Voting Systems lawsuits against them. You're listening to All the President's Lawyers. Support comes from Ring Alarm, providing protection and peace of mind. It's a powerful, affordable home security system that you can easily install yourself. Ring Alarm works seamlessly with other Ring products to protect every corner of your home, inside and out. Best of all, it all works together in one simple app. You can keep an eye on your home from anywhere, right from your phone. Go to ring.com/LRC for a special offer on a Ring Alarm security kit today. This is Josh Barrow, and I'm back with attorney Ken White on All the President's Lawyers. So as we've been talking about for months, Dominion Voting Systems has sued a number of people who made various statements alleging that Dominion led or was involved in a conspiracy to steal the 2020 election from Donald Trump. These suits have been working their way through the courts, and now we have a federal judge who has ruled against motions from Sidney Powell and from Mike Lindell and the MyPillow Corporation and from Rudy Giuliani to dismiss these lawsuits. And so, Ken, am I right in understanding that sort of we were at this stage, you file an initial motion to dismiss that's basically about legal matters? Are the statements that alleged here, if they're false, are they actually conceivably defamatory? Could they have spoken with actual malice, that sort of thing? And the plaintiff, Dominion Voting Systems, in each of these cases has crossed that bar where now they're supposed to go to a trial?
Exactly. So at the start of a case, whether in federal or state court, the motion to dismiss basically says to the judge, even if everything in this complaint is true, it's not enough for them to be entitled to anything. It's an argument that the complaint is on its face legally insufficient to state a claim. And what the judge said here in the face of these arguments was, well, yes, it is. So it's a pretty brutal order in terms of the way it treats the various statements described by Powell and Lindell and Giuliani. It does not bode well for their long-term, what's going to happen to them in this case. You might recall that Sidney Powell argued basically that the things she said were just opinions or arguments, not facts. And as we know, defamation has to be a false statement of fact. And the judge made pretty short work of that, as we all suspected would happen, because Powell so relentlessly suggested that she had proof, that she had evidence that these things were true, that votes were flipped or deleted or things like this. And she framed it in terms of, having video proof and having witnesses and all this type of thing. So the judge said, no, that's not an argument of opinion. That's a claim of fact, or at least they've alleged that sufficiently. The other thing the judge rejected was the argument that they hadn't adequately alleged actual malice. Remember that for a public figure, you have to show that a false statement is made with actual malice, meaning that the speaker knows that it's false or ignores evidence that it's false. And here, the judge said, well, there's enough allegations showing that based on all the evidence that they ignored in making their claims, all the things they had been told, their awareness of the flaws and the things they were relying on and that sort of thing. And Rudy Giuliani in his arguments had mostly relied on procedural arguments and technical ones, and the judge rejected those too, all the ones relating to jurisdiction and whether the damages alleged were proper and that type of thing. So they are now in it, in the case, and you can expect discovery and other proceedings in that case. So that's when the costs for Powell and Lindell and Giuliani start running up, and also when they start having to really participate more directly in the case through things like answering written discovery and sitting for depositions.
What sort of position does that put them in as this advances? Because presumably in a defamation case, one of the key bulwarks of your defense could be what I said was true, which doesn't seem likely to be a productive argument in this case. So if they lose on these legal matters, I mean, I guess, are these things that they can argue again at trial that, they're finding here that, there's at least a plausible case that there's actual malice? It's still for a jury to decide whether there's actual malice. Is there gas left in these claims at later stages, even though they didn't win here? Or are they sort of SOL on the initial round of claims that they were making that were supposed to be the key reason that they were not liable for defamation?
They can keep making the arguments because a motion to dismiss simply decides whether or not there are sufficient facts alleged that, if taken as true, would support a claim. So the next stage at which they can attack them is a motion for summary judgment. So after they've taken discovery and everyone has evidence, a motion for summary judgment basically has one side saying, there are no relevant disputed facts. Undisputed facts show that this is what happened, and that means we win. So that's the next stage at which they can make the argument, and then they can make it again to a jury if it goes that far.
Usually a case like this, if it's not thrown out, it's going to end with a settlement. But I assume this one is probably less likely than usual to end with a settlement. Dominion seems to be motivated not just by a desire for financial damages, but the ability to vindicate its good name in court. The defendants here are sort of wild-eyed lunatics who seem unlikely to also have the financial wherewithal to make a settlement that Dominion is likely to find very interesting. So does that... I assume that means we're relatively likely to head to trial here. How long would that take once we get to that stage? Or how long would it take to get to the completion of a trial?
I mean, a complex case like this, it would not surprise me to see it go for years before it gets to trial, depending on how hard they are pushing it to get to trial. And I think Dominion is going to want to move it along quickly, but it's not going to be sooner than a year, and it's more likely to be multiple years. And I think you're right that it's less likely, substantially less likely than a normal case to be settled because of the personalities involved. Dominion has to vindicate its reputation, because unless it really comes up with a very conclusive refutation of all these claims, it can never get work from local governments again and from states again. It's become too politically radioactive. And the defendants are crazy and make their money off of being crazy. So it's kind of a perfect storm here to drive a case to trial.
So one thing that we talked about in the early stages of this case was the speculative nature of Dominion's damages. The statements that Sidney Powell et al. Made are damaging to Dominion's reputation. As you note, they're likely to interfere with efforts by Dominion to get business. But as this goes on and on and on, that will be less theoretical, and we'll be able to observe actual sales by Dominion. We'll be able to see which jurisdictions continue or cease using Dominion's equipment, whether new ones start using it. So I guess that by the time we got to that trial stage, right, this would be less of a guesswork thing. We'd be able to actually look at how Dominion's business is doing, and that would drive the claims of damages, I assume.
Yes. I mean, particularly as we come closer and closer to the, God help us, the 2022 elections, there are going to be more contracts completed for who's going to be doing the services for those elections. Dominion is going to see its damages start to solidify and see whether it's losing contracts, whether it can still provide services places. You're going to see a lot more open political resistance to using Dominion, I think, from people in local government based on all these conspiracy theories. And that's going to make it easier for them to prove damages.
So, but what if Dominion's business actually does fine? Because maybe it won't. And I think what's happened here is damaging in certain ways to Dominion's reputation. But I think a theme that we've seen around the country is people who actually work in election administration, including Republicans who work in election administration in various jurisdictions. You have Republicans in the state Senate in Arizona who are all about these conspiracy theories and whatever. But then you have the Republican who actually runs elections in Maricopa County, and the Republicans on the Board of Supervisors in Maricopa County are very much opposed to the sham audit that's being done there, and very annoyed about the aspersions that are being cast on Maricopa County's election administration system, which they say is sound, and it does appear to me to be sound. You saw in Georgia, the Secretary of State who oversees elections, who's a Republican, is widely hated by all the Trumpers because he spoke up about how the election was in fact properly administered. So I can sort of see a scenario where the people who actually run the elections, the people who are actually overseeing the purchase of this equipment and services, conceivably might not be put off by Dominion. So what if their sales are fine? Does that undermine their case in the end if we get, a few years out and we're going to trial, but Dominion actually is doing perfectly good business? Does that undermine their ability to get damages here?
Well, it reduces their ability to get damages, but I don't think that this lawsuit or any of Dominion's lawsuits are genuinely about a realistic hope of recouping the billions of dollars they're claiming. The people they're suing don't have it and are not likely to ever get it. They don't have assets like that. It's really recouping their reputation. They're looking for verdicts that say that these things that were said about them were lies, harmed them. And whether they can prove damages of $1 billion or $1 million, that's the realistic goal of their case, is getting those types of verdicts and those types of findings.
Let's talk about Michael Avenatti before we go. So, Ken, Michael Avenatti is now in the defense phase of his trial. He's actually presenting his own case, examining his own witnesses. He's also been filing motions for mistrials, and they're arguing over jury instructions. How does it look like it's going right now for Michael Avenatti in that courtroom in Orange County?
Not well. The government has a case that you do not want to be on the receiving end of. And Michael Avenatti has been demonstrating, as I've said before, that he's a capable courtroom attorney. He knows how to cross-examine a witness. He knows how to make an argument to a jury. But ultimately, the facts he's dealing with are very bad. He's been focused very strongly on this concept that, well, I didn't pay these clients, all the money they think they're entitled to, but the government hasn't proven and can't prove exactly how much they're entitled to. He's going really for an accounting defense. I had expenses, there were offsets, and therefore they weren't entitled to all the money. But that's not really the point. The thing right now that I think he does not seem to be taking seriously enough is the issue of jury instructions. Now, jury instructions are the law that the judge reads to the jury at the end that guides how they're supposed to deliberate. How much the jury actually pays attention and follows those instructions is an open question.
And to be clear, the instruction, this is pages and pages and pages, right? It's not like they give the jury a paragraph and say, rule on this. It's complicated and dense.
Oh, absolutely. It tends to be, 50, 60 pages. It takes an hour to read it all to them, and then you send the copy with them. It's often very complicated, and it's really questionable whether non-lawyers follow it at all. But the core issues here that the judge has been pointing out to Avenatti that he needs to worry about are the definition of what wire fraud is. So wire fraud is an offense where you have a scheme to defraud people, and it's foreseeable that the interstate wires will be used in the course of that offense. Avenatti is basically making arguments, two types. One being that the government hasn't proven wire fraud if it hasn't proven exactly the amount that was wrongfully taken to the penny. And another is that, well, if the victim somehow recouped the money from some other source, like, another wrongdoer, then it's not wire fraud. And neither of those is a thing, Josh. Those are civil litigation arguments about damages, and they're simply not criminal defense arguments. And it really seems realistically that this is kind of a shot in the dark, hoping that you can sway a couple of jurors into hanging the jury by thinking, they didn't prove exactly how much it was, by basically ignoring the law, because he's not going to get a jury instruction that tells the jury that his theory is right. And the judge has been kind of conveying this to him. And on Tuesday of this week, the judge got kind of upset with him because he had not reviewed some edits to the proposed jury instructions that the judge had circulated. And the judge was conveying to him, you need to take this more seriously. So I think he's about to get some bad news in the form of the types of jury instructions the jury is going to hear. Now, again, you never know what a jury is going to do. And it would not shock me for Avenatti to be able to hang the jury by basically confusing one or more jurors about what the issues are. But overall, it's looking pretty grim for him.
So that's interesting that you note that these are valid defenses in a civil case. If you say, well, you're suing me for having defrauded you out of money, but some other party made you whole for some of this, and that that reduces the amount of the tort that I committed against you, or could offset it entirely, right? So that's like, and Avenatti is a civil trial attorney, so he might be used to making that kind of argument.
Right. And again, you just as, you go to the war with the army you have, you go to defend a criminal trial with the facts you have. And if what he has is this idea that the government really can't prove exactly how much money he wrongfully took, then that's what he's going to hope will sway some juror into thinking the government can't prove its case. The core problem with that, and I'm sure the government is going to ram this down its throat in closing, is that the reason they can't prove the exact numbers is because of Avenatti's wrongdoing. I mean, an attorney is obligated to give an accounting to clients of their money, of exactly how much they are entitled to and how much the attorney took and why. And if the attorney took money to cover costs and fees, exactly how much that was. So if there's ambiguity here, it's because of Avenatti. And that's in part why Avenatti was making an argument earlier in the case. Well, I'm not on trial for professional misconduct, and that shouldn't be what the government's going after. And because if he were, he'd lose definitively. But basically, his argument comes down to, you can't find me guilty of wire fraud because you don't know how much I kept because I didn't tell you, even though I was supposed to, which is ultimately not a very appealing defense.
I just keep going back to it. And again, you described like this is something brought in from civil court. Back when the Judge Selna was considering whether Avenatti should be allowed to stand in and represent himself, replacing his own attorney at the 11th hour, he was quizzing Avenatti about his criminal trial experience, which is extremely limited. And one of the things that Avenatti cited as experience was his participation in the criminal trial of himself a few weeks prior in the Southern District of New York. And so it looks to me like, the Avenatti civil lawyer, or as you have repeatedly pointed out on this show, Ken, Avenatti is quite good at certain aspects of civil litigation. Him coming and trying to do that in the criminal courtroom, and it makes me wonder, is Michael Avenatti a good criminal lawyer?
Well, the real proof of that is going to be in this verdict. The thing about being a criminal lawyer, Josh, is that you can do a textbook perfect cross-examination of a witness that will make the angels weep and be in the law textbooks forever and still get convicted. Because it's all about ultimately what the jury does. And the jury doesn't get the nuance nearly as much as, we hope they do. The jury tends to be big picture. And so if he can hang this jury, then we'll say that he's an adequate criminal defense attorney. If he can't, then we'll say he's not.
Let's leave it there, even though there's much more we could talk about. Ken, thank you so much for speaking with me this week.
Thank you, Josh.
If you have questions for Ken White and myself, please send them to us. You can find us on Twitter at LRCKCRW. You can also send us a question at kcrw.com/ATPL. All the President's Lawyers is produced by Sarah Fay. Our production fellow is Nisha Venkat. The show is recorded and mixed by Desmond Taylor, and Todd M. Simon composed our theme music. I'm Josh Barrow. Thank you for joining us, and Ken and I will be back next week with more of All the President's Lawyers.
KCRW sponsors include Amazon Prime Video, presenting All In, the Fight for Democracy, featuring Stacey Abrams, now Emmy-nominated for Outstanding Writing for a Nonfiction Program. All In, the Fight for Democracy is available at consideramazon.com.